Welcome to EUPrivacyForAll Session42 on GDPR, Article 27, Representatives of Controllers not established in the Union. Article 25 on the Representatives of Controllers not established in the Union was renumbered Article 27 on the Representatives of Controllers or Processors not established in the Union. Article 27 lays down that where Article 3 applies on the territorial scope, that is to say, whenever a controller or a processor would be framed by the GDPR, the controller or the processor shall designate in writing a representative in the Union. This obligation does not apply in several cases. First, where the processing is occasional and does not include on a large scale processing of special categories of data or related to criminal convictions and offences, and is unlikely to result in a risk to the rights and freedoms of natural persons. Second, whenever there is a public authority or body concerned. The representative shall be established in one of those member states where the data subjects are and whose personal data are processed in relation with the offering of goods or services or in relation with the monitoring of behavior that is carried out by the controller. The representative shall be mandated by the controller or the processor to be addressed in particular by supervisory authorities and data subject. The designation of such a representative by a controller or a processor shall be without prejudice to legal actions which could be initiated against the controller or the processors themselves. Recital 80 of the GDPR duplicates the key inputs coming from Article 4 of the GDPR. However, there is an additional input to be taken in the end of the recital. The designated representative should be subject to enforcement proceedings in the event of non-compliance by the controller or processor, even if not affecting the responsibility and liability of the controller or the processor. The designated representative will have to face enforcement actions. The GDPR refers to the representative's obligations and duties in a full set of provisions. It is made clear, for instance, that the information to be provided to the data subject would include the identity of the controller's representative. Records of processing activities should mention the controller's representative. Or, additionally, those representatives have the obligation to cooperate on request with the supervisory authorities performing their tasks. In its Article 4 on national applicable law, the Directive 95/46 referred to the obligation of a controller to designate a representative in the circumstances referred to in paragraph 1c, that is to say, the controller not established in EU, but making use of equipment, automated or otherwise, situated on EU territory. What should accountable data controllers and processors get prepared for? They should know that even if not established in EU, but offering goods or services to EU data subjects, irrespective of a payment, or monitoring their behavior in EU, they have the obligation to designate a representative in EU, in writing. There is no such obligation when the processing is occasional, does not include on a large scale processing of special categories of data, or refers to criminal convictions and offences, and is unlikely to result in a risk for the rights and freedoms of individuals. The representative shall be established in one of the countries targeted in EU. He or she shall be mandated to be addressed by, in particular, supervisory authorities and data subjects. Such designation of a representative by the controller or processor remains without prejudice to legal actions against the controller or the processor. Controllers or processors will have to share information on this representative to data subjects, but also in the records of processing activities. designated representatives should be subject to enforcement actions in case of non-compliance by the controller or the processor. So what would be the limits of the obligation to designate a representative?